My name is Jeff Sykes, and I'm going to be your speaker today. Um, I'm here with Bobby. He is my friend and colleague. He's going to handle the questions. So if anybody has questions, please feel free to type them out. Company is Safeguard. We are an estate planning firm in Arizona here. We've got over 50 years of combined experience. We've helped over 20,000 Arizona residents. We provide turnkey estate plans. We do everything from A to Z as far as your estate planning goes. We're going to help you get started if you choose to do business with us. We'll stay with you the rest of your life. We'll help you with your estate plans, and we'll even be there for your heirs when it's time to settle your estate. There's our office there. We're located in South Scottsdale, Hayden and McDowell. This is the part where I have to tell you that I am not the attorney. I'm not here to practice law or give specific legal advice. What I'm here to do is teach you about the ins and outs of estate plans, what a proper estate plan should look like, where you're vulnerable, how to deal with those vulnerabilities. If you do business with Safeguard, you'll be doing business with our attorney. His name is Mark Hall. He's been an estate planning attorney in Arizona for over 20 years. He's got a really strong track record. He's been doing this for quite a while. His specialty is estate planning. And it's important that you deal with attorneys that specialize in the area of law that you're seeking help in. They know that the ins and outs. They're specialists in the field. You get a much better result. And so let's talk about the people that attend these webinars. The first are those of you that have nothing in place. The word for this is intestate. If you're intestate, you're pretty much vulnerable to the maximum extremes of being vulnerable. What this basically means is if you have an estate worth over $75,000 in Arizona, you're subject to being probated. You're pretty much guaranteed to go there. And I'm going to explain to you why and how that happens. But the next group of people that come have a will in place. And a will is the next best thing to having nothing in place. There are vulnerabilities. It's not a perfect document, but it's not a completely flawed document. Having a will in place offers you some level of protection, but there are vulnerabilities that will have to be covered here so you understand what you're getting into if you have a will in place. And then we have those that have a trust in place. For those of you who have a trust in place, congratulations. You've done everything that you can to protect your estate, your family, and everything you've worked hard for your whole lives. A trust is a non-probatable document. So your family would be protected from the costs and the aggravations of probate. It's a very, very harmonious document. And what I mean by that is when you have a trust, it promotes harmony in the family. It's very difficult for people to fight over things. You say what you want to have happen, and that's exactly what happens. And so let's start this off by talking about the problem, probate. I don't know if any of you experience probate, but in Arizona, it's kind of gotten to be an onerous process. It's a time-consuming, expensive process. So let's talk about what probate is. Probate is the judicial process where a will is proved in a court of law and accepted as the valid public document that is the last true testament of the deceased. The first line there catches my eye. Probate is the judicial process where a will is proved in a court of law. That's the first indication about the weakness of a will. Wills were intended to go into the probate court. But what a probate court in fact does is they determine who owns an asset that no longer has an owner on the title. So just say you have a house and you pass away. If you were on the deed of the house as the owner, you're no longer here. Well, now who owns that asset? Well, a probate court exists so that they can determine who owns an asset that no longer has an owner on the title. And that is the main function of probate. And so let's talk about some of the issues within probate. First is the cost. What you're looking at here is a slide. It's a $500,000 estate. And what this pie chart represents is the court costs and the attorney's fees. Fact of the matter is, in Arizona, there's no way we can tell exactly what it's going to cost your estate to go into the probate court. The average ranges from 6 to 22%. For this slide here, we used a 10%. It's on the lower end of the average. It's a nice round number. It's not an exorbitant expectation. It's actually a reasonable expectation. It can be much worse. So if you have a $500,000 estate, you're looking at $50,000 going into the courts. And the red there represents the attorney's fees, which will be about the same as the court. So you're looking at a cost of 20% of your estate. So if you have a $500,000 estate, which is not all that difficult to do, Many people don't realize by the time you add everything up, you get there. You're looking at $100,000 coming out of there. You work awful hard for your money throughout your life. Our goal at Safeguard is to protect you and keep this from happening. You do not have to pay this $100,000, or your state does not have to pay this $100,000. It's completely unnecessary, and we're going to help you, provide you with the information you need to know how to protect yourself. The next issue with probate is it's a massive waste of time. Here it says at any given time there are more than 20,000 active or pending probate cases in Maricopa County, with more than 500 cases being filed each month. This was right off the Judicial Branch of Arizona website. What we have here in Arizona is a really nice retirement destination. All these people move here to retire. Well, when they pass away, they end up in the probate court a lot of times, and they've done a number really clogging the system up. And what that means to you is a wait time of 1 to 3 years to get through probate. In a lot of cases, it can take you 6 months to get a hearing. And so the two biggest issues with probate are it's exorbitant cost, and it's a very aggravating waste of time. There's a lot of hearings, attorneys, courts, judges, and it's very unpredictable. So you don't know what's going to happen. And finally, what you have to understand about probate is it's pretty invasive. They're going to be in your business pretty heavily. They're going to send auditors out to your home. They're going to go through every drawer, every cabinet. Anybody can go to the court, ask the clerk for information about your court case, and they can get that information. Everything that happens in a probate court creates a public record, so it's a pretty good loss of privacy. A judge is going to put somebody in charge of your estate, and they're going to make them place an ad in 3 publications and run this for 6 months. And it's basically to all heirs, creditors, contingent creditors, and persons who may be interested in the will estate of. And now they're basically sending an offer out there for people to petition the court and make claims against your assets. Who's going to show up? You don't know, but this is all part of it. And this has to run for 6 months, so that should tell you about the time frame. And don't forget about when you're in probate and all your assets are frozen, everything's in limbo. It can make things pretty hectic and difficult for the people that you leave behind. Okay, so now I want to give you an example and show all of you how this happens. So what you have here is a slide. Look, think of this as the deed to your home, where you have the title and the ownership with the husband and the wife on the deed. Now you are in Arizona. It's a community property state. And so what you have to understand here is if one person passes away, the other one's going to own the asset. But you have to understand your title needs to be done correctly. I don't know if any of you remember the stack of documents, the one that was about a foot thick that you had to sign when you bought your home. Well, within those documents was the deed of your home. Well, in the course of large transactions like buying a home and all the people's involved in it, mistakes are made. And I bring this up because a couple of times a month in our attorney's office, somebody will have their husband or wife pass away, and that surviving spouse ends up in the attorney's office dealing with a deed that wasn't done correctly. Deeds are very sensitive documents, so you have to make sure that the deed of your house says that the husband and or the wife owns this property with right to survivorship. You don't want to end up in a living probate where you're paying an attorney to go to court to take ownership of your own home because a mistake was made on your deed 20 years ago. And the truth is, most of you have never seen your deed. Most people don't have a copy. You can look at it at the county clerk's office, but it's something I thought you should understand because it's a vulnerability that we all can experience. And so here we have husband and wife own the home. The husband passes away. And now the wife, assuming the deed was done right, is the owner of this home, free and clear. Should not be any issues. Now what happens when the wife passes away? The question is who owns everything? And the answer is nobody. And that is what a probate court does. They determine who owns this asset. So when you leave your assets and you take ownership to the grave, every one of those assets is vulnerable to being probated and having claims being made against it by family, friends, strangers, creditors, anybody. And so that's what you're looking to prevent. And so let's talk about the different ways we can prevent that. The first is wills. We kind of talked about wills. What you've got to understand about the will, I want to hearken back to that line we saw earlier where it says a probate court is a place where a will is proved in a court of law. And the reason it said that because a will was designed for probate. And because of that, about 70% of all wills end up in a probate court. And so let's talk about why that happens. What you have to understand about a will is it doesn't own anything. It doesn't have any legally binding instructions. And so what a will is essentially is a list of wishes. I would like this to happen. I would like this to go to this person. I would like this to go to this person. The problem with a will is it's not legally binding. And what I mean by that is this. If you made me the executor of your will and I was selling your assets and I was keeping it for myself, there's no law that says that I can be prosecuted. I can be sued civilly by the other people in the estate, but I would have broken no laws. And what that means to you in a practical sense, when your successor, not your successor, sorry, that's a trust. When your executor goes to sell the estate and they have that will and they go to sell the family home, well, because the will has not been proved in a court of law and had a judge put a court order behind those wishes and they're not legally binding, they're going to have trouble because they haven't been granted the proper permissions to actually execute the instructions. So if they go to liquidate your home, for instance, when they go to put the house up for sale, the home will never make it through the process. It'll never make it through escrow because the will needs to go into the probate court and get approved by a judge. If your executor goes to take your will into the bank and pull the money out, oftentimes they're going to get stopped in their tracks until they go to court. And so that's kind of how a lot of these end up in the probate court. You know, and so the problem is you have a will, but you still have assets that no longer have an owner on the title. That is the primary weakness of the will. That's where you run into problems. And so the nature of the will leads to issues. It can be contested. Remember, they're not really contesting your will. They're making claims against your assets. And the will does not solve the ability for them to make those claims. It leaves it open. And because of that, it provides a great platform for family disagreements. And I want to kind of give you an example. Think about this. You have an estate and you have 3 people. And oftentimes, not all members of the family are equal. So let's just say you have two of the kids. They're doing great. They've got all the money they need. They're properly invested. They're financially very, very, very healthy. And one of them's not doing nearly as well. Maybe they took a job as a social worker. So they struggle financially. Good people, but they struggle financially. So you decide for yourself that, you know what I'm going to do? I'm going to give 60% of the estate to the one that's a little less fortunate, and I'm going to give 20% each to the others. Well, remember, the will is not legally binding. If one of the ones receiving 20% doesn't agree, they can go to the executor and they can say, look, I'm not happy with this. I'm going to make a claim in court. Well, nobody wants to go to the probate court, but the will is not legally binding. So there's some room for fudge. You can change things around a little bit. So the executor says to the one kid, say, look, how about if I give you a little bit of this? How about if we give you a little more out of this part here? Will that make you happy? Yes, that'll make you happy. Well, now somebody else in the family is saying, whoa, wait a minute. That's not fair. Now you just open the door for the family to start going to war over the assets because nothing's legally binding and it's kind of wide open. And so it kind of creates a platform for families that tend to argue and disagree. It leaves it open for them to do that. And then I want to go back to the privacy thing. When you have an asset that doesn't have an owner on the title and it goes into the probate court, the judge is going to freeze every asset, including the family home. If there's somebody living in the home that is not on title, say for instance, your husband or wife passed away and you met somebody else and they've been living with you for a few years and they're now your significant other and they're living in your house. Well, if you were to pass away, you would want to help them. You'd want to take care of them. You would not want to see them thrown out on the street. So you'd want them to be able to stay there for as long as they want. Well, if your estate goes into probate, because the judge has got to evaluate the estate and the judge has got to protect what's on the property, they throw everybody out. And then they go through every single nook and cranny of your house. They count every bowl, every dish, every t-shirt. And so your loss of privacy is invasive. It's not just a matter of somebody going to the clerk's office and asking for information from the clerk. They're going to be in your home. They're going to be all in your affairs. I want you to understand that. So if you're comfortable with that, that's fine, but I know I'm not comfortable with that. And so what you've got here is wills can complicate the situation. What you have to do is be very honest about the nature of your family. Now, when you're setting your estate plan up is not the time to sugarcoat things. Brutal honesty is your friend here. And so, do you have red flags? Is there family conflicts? Are the kids likely to fight? Is there great disparities in what they have? Does somebody feel like they're always left out? Does somebody get accused of being the favorite? Is there just natural sibling rivalry? There are certain types of families that raise alarm bells. The first kind, this one comes up all the time because it's very common, is the blended family. Everybody remembers the Brady Bunch. The Brady Bunch, that's kind of America's blended family. A wife comes to a marriage with 3 kids of her own. The husband comes to the marriage with 3 kids of their own. And this is wonderful. It takes a broken situation and it makes it whole, and it's really, really wonderful thing in most cases. But this type of family tends to be a problem when the husband and the wife pass. What's often left behind is not a family, but 2 warring tribes. And so a blended family is something that we look at very carefully. It's very much a red flag when it comes to setting up your estate plan, and a will is often inadequate. And next, we talked about the family conflicts. One thing I would ask you to look at is the nieces and the nephews, your brothers and your sisters, not just your kids, your neighbors, lifelong friends. Who's going to stick their nose in your business? Because remember, it doesn't have to be the kids. It can be anybody that can cause a problem and take an estate into probate, and it turns the old apple cart over. And then, do you trust everyone? And when I see this slide, what I think about with my experience is sons-in-laws and daughters-in-laws. They are famous for triggering probate because they say things into your sons and daughters' ears, stir the pot, and pretty soon somebody's making a claim or somebody's unhappy and you're in the probate court. And so these are the pitfalls of a will. And just as a reminder, we are taking questions. So if you have questions about wills, feel free to ask them. We will get to them. But I'm going to move on now to trusts. Trusts are the other way that you can manage your estate. And a trust is the best tool you have at your disposal. And it is a far superior tool to a will. It is much more secure. And so let's get into the trust and we'll talk about how it's made up and how it works. So what we're talking about here is a living trust. And a living trust it's called living because as long as you are alive, and when I say you, if you create a trust, the title for you in this is trustor. When you hear the word trustor, think of the word owner. In the case of a married couple, you're co-trustor. So as long as the trustor is alive, the document is alive, which means it's revocable. It can be changed. Things can be added or subtracted. People can be added or subtracted. Instructions can be changed. It can be completely revoked. As long as the trustor, one of them is alive, the document's alive. And so you have your trustor or co-trustors, and then you have your trustee. When you hear the word trustee, think manager. The trustee is the person who manages the trust. When you're the trustor, you're also the trustee. This is 2 different positions, same person or people in the case of a married couple. Co-trustor, co-trustee, owner and manager. What this basically says is you own this trust and you manage this trust and you have complete control and authority over this trust. What you say goes. And so you can change everything. You can basically add more successor trustees, which is, think of the word manager, successor manager. When you hear the word successor trustee, think executor in a will, because that is the sister position. If you think about how these 2 positions work, they're the same, but they're different. And I'm going to explain to you how. Okay, so in the will, you've got the executor. And we went over a scenario where the executor can run into problems because it's not a legally binding document. It can be changed. And you think, well, as the executor, they have a little more power. What they have is a little more problems because they don't have the full permissions they need to get through the process of liquidating assets. And more oftentimes than not, they end up in a probate court. Well, the successor trustee is managing a different situation. The successor trustee is managing this trust, and the trust is legally binding, which means that if the successor trustee does not follow the instructions in the trust, there is legal ramifications. There are laws they're breaking. There is fraud. There is theft. That changes the dynamic of how the interaction with your family goes. So instead of somebody coming from the family, in that same scenario where one's getting 40% and the other two are getting 20%, if one of the children getting 20% comes to the successor trustee and complains, the successor trustee is simply going to say, look, these are the instructions in the trust. I can't change it. I can't. Anything I do that deviates from these instructions is against the law. And if you try to hire an attorney and contest this trust, no contest clause says you're going to lose your share, and that's automatic. So these are the instructions, and these are what we have to do. And so it makes a smoother ride. It makes for a more harmonious situation for the family, very much so. And then here's the thing. The trust is an ownership vessel. The trust owns the assets. The trust goes on the title of the home. The trust goes on the title of the bank account. So now when the successor trustee goes to sell the home to liquidate the estate, it's going to go into escrow. It's going to clear escrow. And it's going to happen with no permissions. They're already implied. And what that means to you in a nutshell, no attorney's fees, no courtrooms, no costs, no time consumed. What it means is a very smooth and simple transaction or series of transactions where your successor trustee just walks through the process of settling your estate. It's a big difference. And so what you have to understand about a successor trustee, they're not making decisions. What they're doing is following instructions. And speaking of instructions, when your successor trustee comes to pass, your successor trustee is going to be taking over the estate after the trustor is gone. So if it's a husband and wife and both have passed, the successor trustee steps in to manage the trust. The moment that happens, your living trust goes from revocable to irrevocable, which means that the instructions that you leave behind are set. They can't be changed. And for you, that means you're basically controlling your assets from the grave. Your instructions are going to live on until they're executed and completed. And that leaves you some wonderful options. And so with that, let's talk about beneficiaries. Okay, so what you have is beneficiaries are part of a will and they're part of a trust. But there's a difference because of the nature of the trust. When you have beneficiaries in a will, everything that happens when assets transfer from you to your beneficiaries goes in a lump sum. There's no ownership vessel. There's no interim place for the assets to be held. So if you have 3 children and one of them has an issue, it could be any number of things that we run into on a regular basis, whether it's access, Social Security benefits, which if you give a lump sum to somebody that has those benefits, you can severely disrupt their benefits. Or maybe you have somebody that's got a history of substance abuse, and you know that if they end up with $200,000, it could be tragic. Or let's just say you have an irresponsible kid, fun-loving, wonderful person, but they tend not to save their money. They don't really have 2 nickels to rub together. And if you give them $200,000, they're going to throw a gigantic party, buy a boat, and spend all through the money in 6 months. We all know people like that. Well, with a will, you're kind of helpless to protect them against themselves. With the trust, you have a different situation. With the trust, what you have is an ownership vessel. So the asset can be held in your trust indefinitely. And that gives you flexibility on how you distribute your assets. So for that child that's on disability, you can set up your trust so that his share gets distributed to him in a monthly stipend that falls just under the threshold that is not going to interfere with their benefits. And for that irresponsible kid that's going to buy a boat and throw a party, you can give him $1,500 a month. Or you can say, you know what, he's never going to save for his retirement. I'm going to set up his minimum age of distribution for 60, and he can start drawing on the money in a monthly stipend at that point. It allows you this flexibility so that you can make sure that your family is taken care of properly. You also have the option to take care of family members in the next generation. With a will, you can make verbal agreements with your kids and say, look, set aside a certain amount of money, and when the kids turn of age, give them a certain amount of money. And sometimes that goes through and it happens wonderfully. But you know how things work. If they have money troubles, that money's going to disappear. With the trust, you can set up a minimum age of distribution. You can make sure that your grandkids take part in your estate. They share a part of your legacy. You can use your trust to bribe your grandkids. I've seen this done many times. You set up a minimum age of distribution and you put stipulations on the distribution. If you enroll in college, you get a little bit of grandpa and grandma's money. If you get a B average, you get a little bit of grandpa's money. If you graduate, you get a big chunk of grandpa's money. But if you don't graduate, you don't get any of grandpa and grandma's money. You can really, really use your trust for a whole number of things. You can set up money to take care of pets. It's really endless. The key thing to understand about your trust is you decide how you want your money distributed, who you want it to be distributed to, and in what increments. It gives you a little bit of power. And this is going to stay pat because you have a legally binding document that now is irrevocable and it can go on indefinitely. And so that's kind of the differences between how a trust works and settles. And let's talk about a little bit how it settles. So you have your asset. Let's just use your family home. Okay. When you create a trust, you have the trust on the deed of the home. You have the trust on the title of a bank account. So you pass away and your successor trustee now is going to distribute to himself, because you can have the successor trustee can be a beneficiary. That's a question we get all the time. So let's just say you have two kids and you name one of them to be the successor trustee and you give them 50-50. So now you've passed away, your successor trustee goes to your trust, gets your death certificate. The trustee can put the home up for sale. It'll go into the escrow, a new owner will go on the title, and a check will be made in the name of your trust because the trust owns the home. That check, made out the name of your trust, is going to be deposited into a bank account that's also in the name of your trust. And then you have a trust that says that each child gets 50%. The bank is going to write two checks, 50% to each child. The successor trustee hands the check to his brother or sister and puts the other check in his bank account, and boom, it's done. The house is liquidated. And then you have your bank accounts and your investment accounts and all the other assets that you're protecting all go in the same manner, very smoothly and very easily. The main key: permissions are granted, which means no attorneys and no courtrooms. You are going to pay a little more than a will to set up your trust, but you're going to save thousands of dollars on the backside when it comes time to selling the estate. That's really the magic of a trust. So let's look at how it works. Okay, so here, we're right back to where we started. We've got this tile here. It's John Smith and Jane Smith, the owner of the home, the bank account, anything with the title. And so this time we create a trust. So now you have John Smith and Jane Smith, co-trustors, co-trustees of the Smith Family Trust. And now we take the assets and we move them into the trust. And what we have is a trust estate in place. Now what you just witnessed there, moving the assets into the trust, where you see the assets go into this box, a little bit of a misnomer. It's good for kind of a way to give you kind of a diagram, but you're not really putting the assets into the trust. What you're doing is you're putting assets that were in your name and you're retitling them into the name of your trust. We call that process funding your trust. And so what we do is we pull up the deed to your home, put the trust on the title, you sign that, it's witnessed and notarized, and we file that for you. That puts the trust on the title of the home. So now the trust owns the home and you own the trust. Same thing with the bank account. You put the trust on the title of your bank account. The car is an interesting proposition. When you put the trust on the deed of your home, it creates what they call a residual estate. And within your residuary estate is all the contents of your home. Your safe, all your appliances, your electronics, everything in your garage, your tools, everything in the backyard, the front yard, and the cars in the driveway and in the garage. The cars are part of your residual estate. And I bring that up because cars are really very disposable assets. And when you fund your home into your trust, your cars go with it. And that means to you is when you buy and sell cars, they're covered. You don't have to do anything as regards to your trust. Your car will be there. When it comes time to sell the estate, the successor trustee will have all the permission they need to liquidate the vehicle under your residual estate. So if you buy and sell a car every year, you're still okay. You don't have to do anything with your trust, which makes it very convenient. And so one of the things that we do at Safeguard is we are going to take you through the process of funding your estate. It's important that your estate is funded properly, so we are going to help you with it. And I'll tell you why it's important. One of the duties I do here at Safeguard is I do trust reviews. And so they'll make an appointment with us. I'll go out to their home. We'll sit at their dining room table and I'll open the trust and we'll go through all the positions and we'll look at the trust to make sure that everything's up to snuff. See, people have trusts done and 10, 12 years goes by and they don't remember what they did. Well, this is one of the things that I find. These people will go to an attorney, they'll have their trust put together, and the attorney will put together a list of things, to-do list, and they don't pay attention. And they take that trust and they put it on a shelf, and in their mind, they've checked off, they're good. They've taken care of they've protected their family. Well, nobody helped them do their funding, and so therefore, there was no funding done. And so they've had an estate plan in place and it wasn't protecting any of their assets. They had essentially an expensive paperweight for 10 or 12 years. Heaven forbid something would have happened. They would have been very vulnerable. Safeguard will not let that happen because not only are we, as part of what we do, we are going to get you through your funding process, hold your hand, walk you through the process, but we're going to call you every year, 12, 18 months, and we're going to make sure that you haven't done anything that needs to be addressed. You haven't bought a property. And speaking of funding your trust, I want to explain this to you also. When you create your trust, initially there's a little bit of work, that funding process. It's the retitling of assets. We have to take your name off of an asset and put the trust name on the title. It's really not all that it's cracked up to be. It's a pretty simple process, especially with us there to hold your hand. But once you have your trust in place, you're going to acquire your assets and title them in the name of your trust when you acquire them. And this is what I'm talking about. Let's just say you have a home that's in the name of your trust. Well, because you're the trustor and the trustee, you have the full authority and the ability. You don't lose your relationship with your assets doesn't change. So if you put your home up for sale, you're going to be able to do that like you always will have. You haven't created a situation where you need to ask anybody permission. You sell the home, it goes into escrow, a new owner's name goes on the title. The trust comes off the title and that home is going to leave your estate. Now, if you go to purchase a new home, you're going to make an offer on the home. It's going to go through escrow. At that point, you're going to introduce your trust into the process. You're going to say, look, I have a living trust. I would like the trust to go on the deed of this home. The house is going to clear escrow. The trust is going to go on the title. That home will now be part of your estate. If you want to open up a new bank account, you're going to go into the bank, and this time you're going to bring your trust book and you're going to say, look, I would like to open up an account in your establishment. Here's the cashier's check and here's my trust. I would like the trust to go on the title of this account. You'll open the account, the trust will go on the title, and that account will now be part of your estate. If you have the trust on the title of, say, an investment account, say you have a Edward Jones account where you like to buy and sell stocks, you're not going to be restricted. Your access won't be restricted. You're going to be able to buy and sell stocks like you always have. No permissions granted. You're going to pay your taxes like you always have. Nothing's going to change. So now, hopefully that answered some of the questions you might have had in your mind. But I want to remind you, while we're doing this, we're accepting questions. Bobby's looking for them. So if you do have questions, please feel free to ask, because there's a lot of different aspects to an estate plan. And sometimes, quite frankly, I just don't remember to cover every single base. So please ask the questions. So now let's look what we have. We have a trust in place, and John Smith and Jane Smith are sitting there as the co-trustor and the co-trustee. Okay, so John Smith's time is up. Poor John, he passed away. Well, now what you have left is Jane Smith. She's the surviving spouse. She's also now the sole trustor and trustee of this estate. Nothing has happened at this point that triggers her to have to do anything. She doesn't have to remove anybody's name from title. She's in full control and in charge. So if she wants to sell a house or liquidate the estate or make any changes, she has full authority. The good thing about a trust like this is the surviving spouse is not restricted. They are open to live their life like they normally have. Now, Jane Smith passes away. What that triggers is the successor trustee to come in and manage the estate. And so what you just saw was the trust go from being revocable, changeable, to the second spouse passing away, being there's no trustors alive, to the successor trustee coming to manage the estate. Now the trust is irrevocable, can't be changed. The successor trustee cannot change this estate. They must follow the instructions, enabling your wishes to be carried and your ability to control your estate from the grave to be in effect. Now the successor trustee goes and liquidates the estate. What you just saw was a change in management in your estate. And what that means is there's no effect on ownership. The day before you passed away, the trust owned your assets. The day after you passed away, the trust owned your assets. And so the real trick, the real secret to why a trust keeps you out of probate is with the living trust in place, there's no lapse in ownership. There's no period of time, there's no gap when you have an asset that doesn't have an owner on the title. When you've got a will, and you have a list of wishes, but alongside the will, you've got an asset with nobody on the title. You have a lapse in ownership. Though that's your big difference when you're talking about a trust and a will. When you boil it all down, that's what you're looking at. So what I just talked about, what we just dealt with, that whole section of your estate plan that you have to address is the ownership of your assets. And hopefully I've showed you a pretty explicit example of how a trust is far superior to dealing with the ownership of your assets. No lapse in ownership is key. It's key to staying out of probate. It's what makes a trust really not a probatable deal. You're not going to probate. Saves you a lot of money. Okay, so now let's talk about the second aspect of what a proper estate plan must include. What we're talking about is living benefits. And so let's go back and look at a will again. When does a will take effect? A will takes effect when you pass away, which means that a will is limited in what it can do for you when you're alive. You might be in a hospital bed and you might be incapacitated. You may not know what planet you're on. Your will has no effect on that situation because it's not a document that has any effect until after you actually pass away. So when does a trust take effect? A trust takes effect the minute you sign it. The minute you sign it, the trust is in effect in protecting you and your assets. And we talked about ownership of your assets, but what I'm talking about now are these things here: medical issues, stroke, Alzheimer's, some kind of mental incompetence, heart attack, car accident, something that puts you in a situation where you can no longer make decisions for yourself. Here's how this works. If you end up in a situation where you can no longer make decisions for yourself, it is imperative, it is important that you put somebody in position to make decisions for you if that happens. Because if you don't put somebody that you know, somebody you trust, somebody that cares about you in position to make your decisions, both financially and medically, you're leaving that position open. And unfortunately, you're leaving yourself open to having a judge appoint somebody to fill that position. And we're not talking about a family member, we're talking about an attorney from the court. Because in the case of incapacity, without a plan in place, others make decisions for you, which includes the state. And so what you're talking about where you're cared for, how you're cared for. You can end up in some county contracted facility, how it's paid for, what assets are liquidated, how much it's going to cost, what's the level of care. You know, a proper estate plan deals with that. What a proper estate plan does is ensures that those decisions stay within the family where they belong. It's about your dignity. If you don't keep those decisions in the family and you leave it up to a stranger from the court who might be managing 50 other people, you're just thrown into the pile. And then, of course, people always ask, you know, I have kids, I have a wife, how can this happen? I have a husband. Here's the thing, if you don't appoint them and put them in a position to make those decisions, they can't help you. The state's going to step in. And now your kids or your wife or the people in your family are going to have to go to court. They're going to have to give $5,000 to an attorney for the retainer just to make the appearance in court. And then they're going to go back and forth in court for God knows how long and to what cost. And when it comes to a situation of incapacity, a lot of times time is of the essence. To me, this is the big tragedy that happens when a proper estate plan isn't put in place. Your stuff is one thing, but yourself, what happens to you is a whole other matter because you're still alive. And so let's talk about a pretty good example. I don't know if any of you remember Terri Schiavo, but Terri Schiavo, this is back in the 90s. She was a 27-year-old woman, had a heart attack. Of course, 27-year-old women, 27-year-old couples, they don't have estate plans. People tend not to think in those terms when they're 27 years old. So she had no documents in place. And she was wheeled into the hospital and immediately put on life support. She was in a coma. No decisions were made, no appointments were made, all the questions were left open. And so She was there for 8 years. The husband was in court trying to get conservatorship and guardianship so he could make these decisions. And after 8 years, he finally was awarded the decision-making processes, and he had the feeding tube removed. Of course, the mother went back to court, and 3 days later, the feeding tube was put back in. So she laid in a vegetative state for 15 years. And, was it the husband's decision? Nope, he had to go to court. Was it contested? Yes, by the mother. The decision was left open, and an open-ended decision can lead to stuff like this. Can you imagine what it cost to be hooked up to life support for 15 years? This should not happen. If you have a proper estate plan in place, this can't happen. This is something that should not happen to anybody. And so let's look at our own state here in Arizona. Judges and commissioners assigned to the probate and mental health department oversee over 9,000 active guardianship cases, over $500 million in conservatorship assets, and over 3,000 active orders in treatment. And this is straight off the judicial branch side of Arizona. And I bring this slide to you because my point with this is this happens. This is not something that doesn't happen. This is one county in Arizona. And there's 9,000 people that have been made wards of the court with control over them and all of their assets. With a proper estate plan in place, this can't happen because the proper estate plan allows you to appoint people to make these decisions. And so the living benefits of a proper estate plan are the following. Power of attorney for health and financial decisions. So if you're a married couple, the power of attorney is usually assigned to each other. The husband is the wife's power of attorney, wife is the husband's power of attorney, and they're empowered to make the healthcare and the financial decisions of the other spouse if they become incapacitated. It gives the spouse the power of each other's pen in each other's hand. It allows things to be very smooth and easy. If there's an accident and everything turns for the worst and somebody's been incapacitated and they lose their senses to make their decisions, the other person that you put in charge can step right in. No questions asked, very smoothly, without an interruption in anybody's lives, without an interruption in the assets, without going to court, without seeing a judge, without having the state come in and monopolize your situation. Everything goes smoothly. And when you put your trust together and you name your successor trustee, they become the conservatorship of the estate. So when it's time to settle the money problems and the money issues, they're the conservator. They have the power to deal with all of the money in your estate very smoothly, very simply, no courtrooms. And then another thing that must be in place, we call it a living will or the authorization of physician. Some people call it the right to die naturally. But what a living will does is it allows you the ability to make a determination to exactly what happens if you end up on life support. If two doctors of the same specialty determine that your death is imminent and you're in a vegetative state and you're not going to return back to full mental health, you're going to be basically living in that vegetative state, it allows you to make a decision to have the life support removed, allowed to be kept comfortable, and allowed to die naturally with dignity. That does a few things for you. The first, of course, major thing it does is it prevents the state from stepping into that decision. It prevents you from being hung up on life support for months or years and having the hospital and the county absorb your estate just through the cost of the attrition of being locked into that position on life support. Second, it allows you to make the decision, which removes the potential guilt from anybody in your family. Your son or your daughter is not going to go home one night and have to live with the idea that they might have had to basically have the plug pulled on mom, kill mom or dad. So it allows you to make the decision. It's executed and it was your decision. So it works out pretty fantastic on that front too. It's great for your family. And so when you've worked your entire life for what you have, don't you think it makes sense to protect your estate before you pass on? I know that's a redundant question, but I can't insist enough that the potential tragic problems that occur when you don't have a proper estate plan in place, they're real and they happen. And we get a unique perspective being an estate planning firm. We see all the triumphs, all the successes, all the smooth estates, but we also see all the tragedies. And so I feel it would be remiss of us not to explain to you kind of what you're up against. Let's go to Susie Orman. Everybody kind of knows who Susie Orman is. And what she says here is a revocable living trust allows your heirs to avoid probate entirely, keeps you in complete control of your finances while you're alive. You can always make changes to what's in your trust and how you ultimately like it managed or dispersed. Kind of sums up what I kind of went over here this whole time. Thing I'd like to point to is you got to remember, when you put your trust in place, it is not going to affect how you interact with your assets. Everything's still going to be just like it is today, right down to the way you pay your taxes. And so now I've been going on here for about 40 minutes. You're probably asking yourself, so what is this going to cost me? Well, this was taken out of Kiplinger's financial magazine, where they were talking about trusts. And here it says you can usually get a will. And when they say will, there's a will in the body of every trust. So that's part of the trust. A basic trust and a durable power of attorney for financial matters and healthcare for about $2,500 to $3,000. And that, they're talking about a national average. And I'm going to say that's fair. I've seen trusts for as high as $6,500. And I'll go right back to that. Use an attorney that specializes in estate planning. Every time I see a trust, and I see them when I review the trust, right on the inside cover of the 3-ring binder, you usually see the receipts. You know, $3,000, $4,000, $6,500, these outrageous prices. When I talk to the people that had the trust done, 9 out of 10 times when I see those exorbitant fees, it's usually because they went to an attorney that wasn't a specialist in estate planning. They don't have the efficiency. They don't have the nuts and bolts of creating a trust down to a science like an estate planning attorney does. They don't have that efficiency. They don't have the economy of big numbers. They're not doing a lot of them. So they pay these outrageous fees. When you go to an estate planning attorney like our attorney Mark, you know, he's not only does he do it right because he does it all the time, it's what he specializes in, but he does it for much less. And so Mark's regular price, if you were walking to his office, is $19.95. We have an offer for those of you that attend these webinars and are willing to listen to me babble for about an hour. And it's a great offer. It's half price. It's a great value because the things that it's going to include, it's not only, we're not just going to hand you a trust, we're going to go through the funding of the trust. We're going to do full service. We're going to be there to answer your questions and help you along the way. And you know, what does that include? Let's talk about what that includes. Revocable living trust, a certificate of trust. A certificate of trust is a 4-page document within the body of your trust. It basically has all the information financial institutions need to know that certifies that you have a trust, but it leaves out the personal information. And it's the tool you use. Say you have an investment account in New York. Well, it would be absurd to mail this big 3-ring binding to New York, and they don't need to see everything in the trust. And you certainly don't want to fly out there just to put your name on the account. It's the document that you mail to your firm to allow them to put the trust on the title of your account. It's the document you walk into your bank to make changes in the name of, to put an asset that's in your name into the trust name. Also, the pour-over will, that's the will I was talking about that was in the body of your trust. It's called a last will and testament. We call it a pour-over will because it has language in it that helps you deal with an asset that you might have inadvertently left out of your estate by not putting the trust on the title. It allows for your successor trustee to gather that asset, pass it through the trust without having to go into full-blown probate. We don't like to test it. That's why we call you every year. But it's there to act as a tool in case that your successor needs it. Of course, HIPAA waivers. HIPAA is the Privacy Act. You have to get past the Privacy Act so that the doctors can talk to the people you named as your financial power of attorney so they can make decisions. So we put a HIPAA waiver in place so those people can get past that Privacy Act. Of course, financial power of attorney, healthcare power of attorney, living will. We're going to prepare the deed for your primary residence. We're going to put the trust on the title for you. We're going to file it for you. You're going to get a new deed in the mail. That's part of that funding that we do for you, which is part of that complete funding assistance. We're going to go through that whole process. And then one of the best things that we do as a company, we are going to help your successor trustee settle the estate. And this is important because what you have to understand about a trust is it does not need an attorney to settle it. That's one of the magical things about a trust, which means there's not going to be an attorney feasting on your estate when you're no longer here to defend yourself. You're not going to have an attorney turning your estate into their retirement program. We're gonna make an appointment with your successor trustee because right on the inside cover of your trust, it says right there, if you're the successor trustee in the process of liquidating assets from this estate, please notify Safeguard. And we make an appointment, we bring them into the office, and we walk them straight through the process. We remove all the mystery of the legal documents. We take a very stressful situation. Obviously, for some people, it's the most devastating event of their life. They've just lost their parent. And we don't want them to feel stress over settling this trust because it's not stressful. We make the priorities. We give them the numbers to call. We tell them what to say. We're there for them the whole time to ask them questions. We might even be there to help settle some disputes within the family. We make everything go very smooth. It is a wonderful service that we offer, and it's included in that $9.95. The key with this is you don't need an attorney to settle your estate. You wouldn't hire an attorney and pay him $300 an hour to sell your house or get your life insurance or get your bank accounts. We're going to help them do that, and it's not going to cost them anything. You pay the $9.95, and that's it. You're going to be taken care of. Also, we're going to give you an emergency contact card. And that emergency contact card looks like a little credit card. It's got our name and number on the front. It's got your power of attorney's names and numbers on the back. So if you get in an accident, the first responders can find that. They can notify us. We can fax documents to the hospital, but they can get in contact with your power of attorney and make sure that they get to the hospital in a timely fashion. And you know, we work here at Safeguard with full transparency. I want to explain to you, there's two types of changes do you make to your trust going forward. One of is financial, buy a home, add a home, you know, add a bank account, close a bank account. Any of these changes will always be there to help you and it'll never cost you anything. However, if you need to amend your trust, which means make a change to the body of your trust, when we set up a trust, we set it up with full redundancy, which means everything has a backup. If you name a successor trustee, we need somebody that's there that's to serve in the case that that person is either unable, meaning they're not here, or they've become mentally incapacitated. You need a replacement for that person. So those are going to be put in place. But let's just say your successor trustee gets in an automobile accident and they're abusing pain medication, and you're not really trusting, they're not as rational as they used to be, and you want to remove them from that position. Well, that requires an amendment. Look, our market's not looking to make a living on amendments. We used to do amendments for free. What that led to is very fickle people making irrational decisions to add and remove their children. Their daughter makes them mad. They want to remove them one day, and 2 weeks later, they want to put them back. And it became chaos. And the attorney's not left with a living, breathing moment to bill another hour. He's doing free amendments all day. So we put a small fee. He does them for about a third of what a typical attorney does it, a couple $100, somewhere in that range, where he'll do your amendments and you can remove somebody and add somebody. But I just wanted you to understand, I don't like surprises. We don't do surprises. The only thing that would change the price of that $9.95 when you sign up is if you have multiple properties. If you have one home, you own a primary residence, we're going to put that deed in the trust for you. It's included in the $9.95. If, however, you have, say, a couple of rental properties, each additional property is $120 each. And so that's the transparently. You're going to like working with Safeguard. We are good at what we do. We take pride in what we do. We're experts in this. We're going to treat you like family because that's kind of what Safeguard is. It's a little family. And just take a look what people say. One of the things I'd like to point out, I feel relief now. I can tell you, you've probably been putting this off for a long time and it's been sitting in the back of your mind. It's very common. I feel relief now is one of the most common things that we see. It's the thing, but this is what people say about us. When you come to an estate plan, we want you to talk to people about your experience. We're proud of what we do. And so, you know, we've got great reviews. You know, we went to a Safeguard meeting at our community center. We initially went to renew our will that was 30 years old. You know, we decided to do a trust. Our appointment, we signed all the forms necessary, walked out of the office with our trust. We feel very relieved. There that is again. Have a plan for our family and for our future and their heirs. They were extremely helpful throughout the process. We would highly recommend Safeguard to anyone who needs help with planning their future. We're very proud of our reputation. And so if you are interested in moving forward in a trust, we would love to earn your business. We will do a fantastic job for you. If you want to start a trust, it's easier than you might think. The way that you start a trust is it deals with the positions in the trust. Who is your successor trustee? Who are your beneficiaries? Who are your children? Who do you want to name as your power of attorney? Well, we have a form here. If you look at this web address on the bottom of this form, it says http:// safeguardyourestate.com/form. What that is a web address. And what it does is it takes you to a form. If you jot that down or type that into a web browser, it'll take you to the form. You fill out the form and press submit, and then we can get in contact with you and we can answer any of your questions. We can assist you in any way. If you want to get a trust started, it's a very easy process. What we'll do is we'll talk to you for a few minutes. We'll look for an appointment on the attorney's calendar, and we'll set you up with the attorney. You'll come in where you can meet with the attorney one of three ways. Of course, in person is always the best. I prefer to look somebody in the eye, especially attorneys. I've told you how wonderful Mark is, and he is. But we want you to come in and meet Mark, talk to him, let him talk to you about your estate. If you like what you hear, you'll move forward. If you don't like what you hear, you're not going to be obligated. But type in that http://safeguardyourestate.com/form and put that into your browser window, fill out the form, push submit. For everybody that does that, we're going to send you a free gift card. We're going to buy you lunch. But otherwise, we'll call you. We'll answer any questions you have. If you want to get started, we'll get you on the road to getting your estate protected, protecting your family. But I want to thank everybody for coming. I hope that you learned from this. I hope I answered all the questions you had. I'm going to leave this open. We're still open to questions. Me and Bobby will be monitoring it. And anyways, I hope to hear from you. Fill out that form and we'll talk to you in a few minutes.